That detective lied to me. He lied to me, completely lied to me.
Court will start with State of Kansas versus Gage Douglas Apel, case number 2024 CR 341. Amber Norris appearing for the State of Kansas, Gage Apel appearing from the jail Zoom location. Mr. Watts, I think this is your case. Jim?
May I?
Yes, sir. Judge, I don't have that file with me. I think it may be Joe's.
I don't have
The
an issue
docket
with appearance from him. The order of
docket
appointing
sheet
is for
Chris
you.
Pate,
That's
okay.
what I was going off.
It's Chris
shows
Pate,
Chris
Your
Pate.
Honor.
I will get a hold of Chris and see where he's at.
May I ask a question, Judge?
You may.
Okay, I'm not quite sure where this is going at what point in time, but for my own safety and sanity, if that's still of matter, I would have liked to have requested far before being placed in jail, that I would have been put in some sort of a witness protection somewhere away from the state of Kansas, as I've been fearful for my life for years now. And so, I mean, just to be here in front of a judge and finally have a camera and be on a court docket, I can't believe that it's taken this long. I've been on the Kansas Missing and Exploited Children's list since I was in elementary school. And I have no parents. My grandparents have passed. I have no family.
Okay, you're an adult now, Mr. Apel.
Correct.
Okay.
And
And you
Your
say
Honor,
witness protection program, that would be a program that would be essentially set up by prosecutors, not a judge.
Right.
And that usually would be based because you have witness information against others. So, I mean, I
That's
don't
not
make
what
light of what you're saying, but I don't know if that's something for the state district court to be addressing here, Mr. Apel. What I really want to address here is the status of your current case before this court. And apparently, Chris Pate was subsequently appointed after Mr. Watts was initially appointed. So there is a new attorney in your case.
Right. I don't have a record if that's where we're going with that. So I may be a grown adult now, sir, but I didn't get here by happenstance. I'm a survivor. I'm 6 years sober. I'm not trying to collect names so that I can collect a check and skip to another state. I'm from Butler County, born, bred, and raised. I'm not saying that proudly all the time. I'm just asking for a chance.
I'm unable to take your call right now. Please leave me a message and I'll get back to you as soon as possible.
When you have finished.
and Your Honor, I don't know I don't actually have a copy of the filed order appointing, but the one that we had for Mr. Watts was file stamped July 23rd. It's, August 12th. I'm not sure whether or not he would have gotten it in time to get it on his calendar.
I was in contact with him. He knows of it.
Okay, so has there been a formal order appointing Mr. Pate?
Yes.
Okay. Mr. Apel, we're going to recall your case later in this docket. It's a long one today. So we'll call you back in a little while and we'll deal with your case again, okay?
Okay. And then before I go, may I just, if I'm able to survive and live another life, I don't want to die of a stroke in jail. I really am so unfortunate that this is a reality. And if I could wave a magic wand, I would redo it all. So I beg of everyone that can hear me, please give me a chance. That's all I have to say.
So noted, Mr. Apel. We'll call you later in the docket.
Thank you, Judge.
This is State of Kansas versus Jesse Greenwell. It's case number 2024 CR 236. Amber Norris appearing for the state. James Watts as defense counsel. Mr. Greenwell appearing from the jail Zoom location. Sure why this case hasn't progressed further than what it has. What announcement is made regarding preliminary hearing right at this juncture, Mr. Watts?
Your Honor, I met Mr. Greenwell last Thursday at the jail. We would ask this case be set for preliminary hearing, please.
Currently, the court's looking at Wednesday, October 2.
Can I get a bond reduction?
Let's take care of our scheduling business first, Mr. Greenwell. Will that work for council's calendar? Wednesday, October 2?
Jim, that's Judge Webster's jury trial date. Wednesday, October 2nd, Thursday, October 3rd.
Okay. Well, that's what that is then.
And there are approximately 40 cases probably set for jury trial.
Well, she's going to work fast.
Thursday, October 17, Mr. Watts. Wednesday, October 30. Mr. Greenwell obviously must be present at that time and fully participate in it. Wednesday, October 30, 9 o'clock. Currently, there was some issue raised by the defendant himself regarding bond reduction. Originally, at first appearance, bond was set at 10,000 cash or surety. That appears to be the current order as well. What happened to the $3,500 that you were supposed to get back, Mr. Greenwell?
I was supposed to get back. I've been in jail the whole time. They've got my money.
Judge, it is also almost certainly in a evidence locker. It has not apparently been turned over to the jail as part of his property. It's in an evidence locker.
So what evidentiary value does this money have in this case, Ms. Norris?
Your Honor, without taking a lot of the court's time, I have actually not read through this case, so I really couldn't say, to be honest with you. But I mean, I suppose it might have something to do if they thought that maybe he was, working on some distribution or something of that matter. But I don't know.
What I don't know is that I don't have any documentation that the amount of $3,500 is being held. That's what the defendant related to this court. But obviously the court doesn't have possession of it.
And Your Honor, I don't know either. I can make a note to check with law enforcement regarding same.
Judge, I can tell the court the affidavit relates $3,802.69. As the current case is currently charged, I don't know that has any relevance.
3802.69 was taken from the defendant.
Yes, sir.
I want to establish cash bond in this case at $3,802.69. It would appear that the prosecution, if you will, though not in direct hands of the court, this money is being held, and the court will hold that money as security for his bond. Mr. Greenwell, where would you go if you were let out?
Probably to
Evidence.
probably to my mom's house, and I'm probably gonna rent somewhere when I get out. And
Okay, where's your mom's house?
in Wichita.
All right. Mr. Greenwell, I don't like this idea that this money got taken from you is being held. I have no indication there's really evidentiary value to it. I'm going to give you the value. We're going to hold that money as security for your release. Okay? So I'll reset your bond at $3,802.69. Acknowledge that that money is apparently being held in the hands of law enforcement and would be available to secure Mr. Greenwood's bond requirements, appearance bond requirements, should he fail to appear. We can review this in the future, Mr. Greenwell. But for now, I think that order will allow you to be released on this case now. Okay?
Your Honor, I understand the court's order, but until I get confirmation from law enforcement, whether it be people out at the jail or at whatever, the law enforcement agency that works this case, I don't know that I can. I mean, I haven't even confirmed that, whether it's the sheriff's office or the jail that even has the money.
Well, Judge, I can tell you from the affidavit, it's the sheriff's department. The affiant is a Michael Malott from the sheriff's department.
Well, Your Honor, the sheriff's department definitely took it when they arrested him, but whether or not it's actually in evidence at the sheriff's department, I don't have the documentation, or if it's in his property at the jail, which I don't know that I have the documentation for that.
Either way, I'm going to order a hold on the money. It's in the possession of the sheriff's department somewhere at this point.
I assume
And I'm
so.
going to use it as security for his appearance bond. And I'm not going to order that money to be released. I'm going to order a hold be put on that money pending further order of the court. But I am going to order that Mr. Greenwell is eligible for immediate release. As long as you show up, because you understand what happens if you miss the court date, Mr. Greenwell, you're going to forfeit that money on the bond.
Yes, I'll show up, Your Honor.
I think you will. I think there's a lot at stake here for you. But I'm not going to let the sheriff's office take away your ability to make a bond. I just don't like it. This was all discussed back on May the 20th, and he's still sitting in jail. So,
Your Honor, I don't know if it was discussed much then, but I do know on 7/15 that it was brought up again. And I apologize. There was a note, but I did not see it until today.
I don't know about 7/15. There's no notes to that effect, but I see the lengthy discussion in the docket notes about it way back in May. So, court's made an order. I'm going to take my chances on Mr. Greenwell showing up for court when he's supposed to. And the next court date's Wednesday, October 30th, 9 o'clock for evidentiary preliminary hearing. Mr. Greenwell, I'm going to order you to be one of two places. You need to pay attention here. You need to either be in Mr. Watt's office beside him, okay, to do Zoom, or you need to be at the Judicial Center. You can always appear at the Judicial Center, and the Sheriff's Office will get you to a Zoom computer, okay? One of the two places, but they're both in El Dorado, real close to each other. I'm not going to allow you to appear by Zoom from any other location, all right?
All right. Thank you.
Okay. All right. Greenwell matter is in recess. Okay. Who is this individual that just sat down at the jail Zoom location?
Wendy Scott.
Your case, Mr. Watts?
It is, Your Honor, and I will tell the court I received the discovery, and at this point, the place is quite considerable. I got it late Friday afternoon. I've been reading through some of it this morning, but as Your Honor is well aware, because I've been in front of Your Honor most of the day, I've not had a lot of time to read through this case.
Okay. I just don't want Ms. Scott compromised. Is she being held solely as a result of this case?
As far as I know, Your Honor.
All right. This is the state of Kansas versus Wendy Scott. It is case 24 CR 346. Ms. Scott appearing from the jail Zoom location. James Watts as defense counsel. Amber Norris for the state. In an abundance of caution, I'm inclined to set this for an evidentiary hearing. Again, I'm already kind of getting these dates out there. I don't want to have any further delay in establishment of an actual evidentiary hearing date. So the court will go ahead and establish one now, because it is going to be out of ways as it is. Starting at 1 o'clock on Wednesday, October 30. All right. Ms. Norris, is there anything further we need to address from the state's perspective on this case?
No, Your Honor.
All right. Mr. Watts, anything further at this time?
There is, Your Honor. My client would ask me to take up the matter of bond. It's my understanding that she is currently being held on a $100,000 bond, which is obviously well beyond her ability to have any hope to meet. And I suspect was set with the intention of making it well beyond she having any hope to meet. She has 3 children. 2 of them are at home. Their 18-year-old daughter is currently watching another child. She's from Nebraska, but she's been living in Wichita for the last 3 years. She was working at Breakthrough, which is an assistant program for vets. Has been working there for a year, doing support for disabled vets. It sounds like, well, I get into that. She has a residence in Sedgwick County, in the area. She has children in the area that are dependent upon her. As I said, it appears that she has an 18-year-old daughter that's currently taking care of a younger daughter. She's at 30 Central in Wichita. We would ask that a bond be set that she has a chance to make. And I understand the purpose of bond. Purpose of bond is to assure her appearance. Purpose of bond is not to make sure someone is held so they can't get out. And when we set $100,000 bonds, that's typically the reason why we set them, is to make sure they can't get out. Judge, I think a bond in this case that might be appropriate would be in the $15,000 to $20,000 range rather than $100,000 range.
State's response, Ms. Norris?
Your Honor, we did request 100,000 based on her criminal history. She's likely a B on the grid, so which makes her presumptive prison. She's for sure a C based on the history that we could see. But the nature and circumstance of this crime are actually, pretty significant in that they stole from an injured, an 86-year-old woman, basically from her home, left her on the side of the road, and took her dog. She was found, Flock puts this individual in the car, the Flock systems where they take photographs of vehicles and license plates, put her in the car, the stolen car. She makes some admissions, but she has several flee and eludes. She has an aggravated battery LEO, multiple forgeries, lots of shoplifting, false informations, obstruction, tampering with evidence.
Is this from Nebraska or this is from Kansas? I've had these cases are from like, I could say probably 20 years back.
And Your Honor, her flee and eludes are from 2020. A lot of this stuff is from Nebraska, and it starts in 2004 and doesn't stop till 2017, which I think might have been when she moved here. And then she also has some felonies, theft issues in 2015 from the state of Iowa. She only has a Kansas ID. I don't believe she has a legitimate driver's license. The bond seemed appropriate based on the types of offenses that we're talking about here. The vulnerability of this particular victim. Her own criminal history puts her basically in a presumptive prison. She's not originally from here. She has criminal history in 3 different states. Your Honor,
And please. I
believe
got
that
ECF and I'm trying to fight to get my baby. I'm not gonna run. I promise. I'm not here just to be. I did not do this. I was told to cooperate with the situation and I would get out of this. That detective lied to me. He lied to me, completely lied to me. I didn't even know when I was questioned. I didn't even know when I was ICU. I was laced.
Okay.
Nobody's taking none of this in consideration.
Wendy, please don't say anything else.
This court had the opportunity to review at least some of the facts of this case through its review of a prior affidavit supporting a warrant. I am familiar with the facts and circumstances of this case as outlined, I think, very appropriately by Ms. Norris here on the record. I will just note that the charges in this case include aggravated robbery and kidnapping, both level 3 felonies, which would make these presumptive prison offenses in and of themselves, regardless of criminal history. And of course, obviously, the criminal history of its defendant also gives this court some reason to pause. Ms. Norris, I'm curious, was the small dog Chloe ever recovered?
not that I've heard of yet, Your Honor.
Tragic. The circumstances of this case are flagrant and indeed tragic in regards to the elderly victim in this case. The court does find that there is a public safety component to the review of any bond situation. She is a considerable run risk due to her criminal history and the fact that she's facing prison if convicted of one or more of these charges. She's also got flee and elude in her record, avoiding law enforcement and responsibility. And therefore, the court does believe that the bond is appropriately set, and the court will leave it where set at $100,000 cash or professional surety required. If she makes that bond, she will be restricted to the territory of Butler and Sedgwick County, Kansas only, and will be required to wear an electronic monitoring device to monitor her location. But the amount of the bond and type of bond remains the same. The request for modification is denied at this time.
Sir, I just I'm taking my rights.
I believe that was the last matter to be taken up regarding the Scott matter. Ms. Scott, I'm not going to grant any modification of your bond. If there's nothing further at this time, the Wendy Scott matter is in recess, and we'll move on to another matter on the docket.
All right, we'll go on the record. Cases entitled State of Kansas versus James Brent Watts, case number 22 CR 83. Would counsel announce appearances, please?
Cheryl Pierce on behalf of the state, Your Honor. Judge, I don't know if you recall, but Mr. Watts represents himself. James B. Watts is self-representative. James R. Watts is here as standby.
Correct. So James R. Watts as standby counsel. James Brent Watts has been representing himself on the case. Mr. Watts, is it still your intention to continue to represent yourself on this case?
Yes.
All right, we need to get this case set for prelim. It's been set a couple of previous times. Mr. Watts had been declared not competent to stand trial. He has now been to Larned, and they've I received a screening. I don't have that in front of me. Ms. Pierce, or do you have that in front of you?
Judge, I do have the report that was sent from Larned on August the 2nd. I also forward that to James R. Watts as well. I didn't provide that to the defendant as I would have to go through jail to do that, but I have no problem doing that. The opinion, and I'll just read this into the court for the most part. Mr. Watts has a sufficient understanding of his current legal charges, the seriousness of these charges, and possible plea or possible penalty. He distinguished between evidence and witness and or the part each has with respect to his defense. He has an adequate understanding of the roles of the court officials and understands that he wishes to represent himself. He understands the significance of the case relevant information and more general legal information available to him. In addition, Mr. Watts understands how to communicate preferences regarding how the case will be handled. Further, Mr. Watts has a basic understanding of his role as the defendant and how he will be treated by the legal system in a number of important ways. Mr. Watts' responses to semi-structured questions demonstrate that he understood and appreciated his current legal situation. Currently, Mr. Watts has the ability to maintain a consistent defense, to listen to witnesses, and to respond to distortions or misstatements, to make a simple decisions in response to well-explained alternatives, and to testify in his own defense if necessary. Thus, at this time, it is the recommendation of the examiner that Mr. Watts be found competent to stand trial. Additionally, based upon Mr. Watts' history, it is likely that if he is not maintained on psychotropic medications, which he willingly takes, he would likely decompensate and his mental health would deteriorate. Therefore, it is respectfully requested Mr. Watts be maintained on psychotropic medication, monitored and managed by a psychiatrist. And that's the opinion of the report. It is signed by Roy G. Daum, D-A-U-M, and it is dated 8/2/24.
All right, thank you, Ms. Pierce. And I did have an opportunity to review that report, and based upon those findings, I will order that Mr. Watts is competent to stand trial, and we can proceed moving the case forward again. Mr. Watts, is it still your wish to have a preliminary hearing in this case?
Yes, it is. Also, I need to get a permission or whatever, and my mother will have to pay for it. I'll need to be in contact with my parents, but I need to take a polygraph test. They're saying that I shoved them down. I did not shove them down. I need to take a polygraph test on that, and then I also need to take a polygraph test on to introduce for my credibility. I will take the stand, and the polygraph would just be for to introduce his credibility. But anyway, the firearms I purchased on arms list and newspaper and elsewhere. All the
Mr.
firearms are
Watts,
mine.
I don't want to get into the facts of the case. Right now, this isn't the actual preliminary hearing. I want to set a preliminary hearing date. I think what I'm going to do is just set it
Okay.
all day. That way we've got the time if we need it.
Okay.
All right. My preference is to do it in person. Mr. Watts, we'll set
Yeah,
it as
that
we'll
was-
set it as an in-person hearing, and they'll transport you over here to the courthouse that morning. We'll start at 9:00 a.m. evidentiary preliminary hearing. Now, regarding a polygraph, that's something you'll have to motion the court for. That's not something that's typically done. You'd have to make arrangements to have that paid for. So,
Do I have to go to the court, or can I just make sure my parents can pay for it and go ahead and do it?
well, I think if you can pay for it yourself and make arrangements to have it done at the jail, I don't think you have to motion the court for it.
Right. Because I won't need it for credibility, because both my parents have got scared on the prosecutor having something to do with them on not evidently resisting me enough. The firearms were mine, and I had them hid in the house, and I removed them. They weren't going to stop me.
Okay, well,
But,
Mr. Watts, again, I don't want you to say something here that might incriminate you down the road. So let's not discuss the facts of the.
Oh, I possess
Okay.
firearms. I will never give up my right to firearms. As long as the heavens laws of the universe that everybody can have firearms. Arms, not just firearms, arms.
All right, Mr. Watts, we'll see you back on October the 1st at 9:00. Ms. Pierce, anything else today?
Not that I'm aware of, Judge.
All right, Attorney Watts, anything?
No, Your Honor. And Your Honor, I'll ask Mr. Watts, do you want me to come to the jail to review any sort of procedures or assist you in any way?
Yeah, I will need probably some assistance. I don't have access to contact. I need access to contact. My mother is my guardian, and she has access to all the finances. I really need to have access to contact her and communicate with her. They also take care of a trust, properties and stuff. I know of things that need to be done out there, and I've been holding off for over 2 years now and getting stuff done. But this can't go on forever, and me not have contact with my parents, guardians, and trust.
If you all want to have a private conversation, we can do that. Sounds like Mr. Watts or Attorney Watts has made an offer to come visit with
Yeah.
you. Is that accurate?
Yes.
That's correct, Your Honor. I've got a jail visit scheduled later this week, and I will add Mr. Watts to that list.
Very well. All right, Mr. James B. Watts, anything else?
I think that covers it. We can visit there and see whether we have anything else. I visited the jail.
Sounds like a plan. If there's nothing further, we'll be in recess. Have a good evening, everyone.
All right.